Commissioner Hayward, can you hear me?
Yes, I can.
Okay, just wanted to make sure. We'll get going here in a couple minutes.
No worries.
All right, well, good morning and welcome to today's FPPC Law and Policy Committee meeting. Ms. Linker, would you care to call the roll, please?
Commissioner Hayward?
Here.
Chair Matich?
Here. All right, we'll begin with public comment for items not on the agenda. Do we have any public comment either on the phone or digitally for items not on the agenda? All right, seeing and hearing none, we'll move to item 2, approval of the April 2020 Law and Policy Committee minutes. Commissioner Hayward, do you have any edits, questions, comments on the meeting minutes from April?
I do not.
All right. Any public comment on the April 2020 Law and Policy Committee meeting minutes? Hearing none, do we have a motion to approve the meeting minutes?
I'll move approval.
All right, second, Ms. Linker.
Commissioner Hayward?
Aye.
Chair Matich?
Aye.
The motion passes.
Commissioner Hayward, I'm wondering, my sense is that we may have a fair degree of participation with respect to item 3. And so I was wondering if instead of taking item 3 now, we move to quickly get through items 4, 5, and 6 and reserve the balance for item 3.
Sure, let's do that.
Great. All right, then we will move to item 4 at this point, discussion of modifications to the Streamline program regarding adding a second tier. I believe we have Chief of Enforcement West here to present this afternoon. Good afternoon.
Hello. You can hear me?
Yes.
Okay, if you hear Spanish music in the background, that is not my fault.
Okay.
I'm getting my patio installed, so they're prepping for the concrete.
Gotcha.
It happens to be right outside my office.
Okay.
So I wanted to present this today, and I'm very excited because this is something that has been on my mind for a while, and wanted to present it to Law and Policy as a novel approach, new idea of how to have a workload buster for enforcement. So when I was looking at the Streamline regulations and how to modify them and to be more inclusive or to loosen the thresholds or to make them work better to where the commission wasn't seeing these mainline cases that we've had to present that were 1 or 2 counts, and they're not of the issues that the commission has considered the most serious or egregious or intentional. They're not laundering, they're not the personal use, they're not the things that the commission has said, this is what we want you to spend resources on. So I've been racking my brain trying to figure this out. So I think the answer is to add a second tier to Streamline as opposed to modifying a bunch of the rules to allow other violations to be included. And I think what this will do is it will address the public's concern that these violations are getting too light a penalty because they would have an increased penalty structure. Because obviously we would not want to treat them the same way that we're treating a regular Streamline case. We would want them to have an enhanced penalty of some kind. But what I've been looking at in the research is that a lot of these cases are going to the commission, getting a full mainline stipulation written, negotiating over the language. The commissioners then have to really concentrate on the agenda and read the language through all of these campaign cases that have fallen out of Streamline. And so a lot of time and energy is being taken on these cases that have fallen out of Streamline because they're just not meeting some of these percentages. So with a second tier, then what we can do is we take the thresholds and we add another threshold to where if you've just barely missed it, but you are below this point that we consider egregious, these are the violations the commission has already decided should be handled in a faster, more expeditious program. And so we're going to then just give you an increased penalty, but you'll get that same fast program that will then allow some of these cases to be processed much faster. So I'll give you an example. If you see the last couple agendas, what you'll see is a lot of cases that have been excluded from the Streamline program because they have, one of them was 20% of the cases, or 20% of the missed reporting, and it was his own money for the whole statement period. But yet, since it was over 20% of the amount for that reporting period, it was excluded from Streamline. So these are the kinds of cases I'm talking about. Or one 24-hour report wasn't filed in the last 16 days, but it can't be Streamlined because that's one of the exclusions for Streamline. So I think that if we have this higher tier with an increased penalty structure and perhaps a little additional information on the stipulation about why it didn't qualify for the first level of Streamline, I think that we could really get a hold of this type of workload that's taking up not only the commission's time with the agenda, but also enforcement's time and the respondent's time, when it's not really getting any different result than you would get with just a higher penalty tier structure. That's my pitch.
All right. So what do you think about that, Commissioner Hayward, just conceptually at this point? Is that something you think Chief Enforcement West should think about and present to us?
Yeah, no, conceptually, I'm all for, a clearer, more predictable enforcement system. If especially since we always retain the option of pulling something back out of Streamline if for whatever reason it's not working the way we think it's going to work. Oh yeah, absolutely.
Great.
Okay. So Chief Enforcement West, what's your thought on timing then? It sounds like, and speaking for myself, I also am interested in you putting more sort of detail together and presenting to the full commission. I think it sounds like a great idea. What's your timeline on being able to do that?
Well, I've been trying to put together a draft right now to get over to the legal division and working with enforcement staff to try to make sure that we're capturing everything. So I'm hoping, my goal is to get a pre-notice in June when we're pre-noticing the other enforcement regulations. Enforcement has been taking a lot of time working on those. And so if we also kick out Streamline at the same time, I think it could be a good thing to have them all getting done at the same time.
Okay. Excellent. Commissioner Hayward, any other questions for Chief Enforcement West?
No.
All right. Do we have any public comment either on the telephone or digitally on item 4? Hearing none and seeing none. Chief Enforcement West, I think you are authorized to go ahead and put together your proposal and present it as part of the reg packet for pre-notice consideration in June.
Great. Thank you very much.
Thank you. All right, we'll now proceed to item 5, discussion of advice letter process. This is something that General Counsel Bainbridge, I think, wants to address.
Yeah, now it's time for my pitch.
There you go.
So the advice letter process currently, what we're talking about is the review of the advice letters by the commission. The current process is to publish the advice letter report that we do every month on the agenda as its own item. That's a fairly new process. I think it was July of 2018 where we started doing it that way. The history of that was previously the advice letter report had been included with the legal division report. At the time, there had been some questions about certain advice letters and what action could be taken on an advice letter if commissioners disagreed with the advice given. And so the decision was made to move the advice letter report as its own item on the agenda. I think the thought was this would be easier for people to find and be aware of, and would make it very clear that action could be taken on those items, as opposed to the chance that it would just be informational when it was contained on the legal division report. What I am suggesting now is that rather than including the advice letter report as an item on the agenda as a matter of course, we would produce the advice letter report sometime around the end of each month. It could be distributed to the commissioners as well as the public at that time. And then if there are particular advice letters that commissioners are interested in discussing, potentially withdrawing, or just have questions about and they'd like to agendize it, they could request that it be put on the agenda. Obviously, the chair is in charge of what goes on the agenda. The benefits of this would be it would provide much better notice to anyone interested in the letter itself that a particular letter would be up for consideration, as opposed to you have a list of 15, 20 letters every month on a report. I've heard from at least one member of the regulated community who felt the need to show up at meetings when their clients' letters were on the agenda, on the off chance that a commissioner or a member of the public would want to talk about that letter. So I'm sympathetic to that. I'm also selfishly, it's like studying for a pop quiz every month for the people who present those advice letters. And I think not only would our life be easier, but I think we could give better counsel to the commission if we had a heads up of what letter they would like to discuss. We could have reviewed it more thoroughly and maybe be able to answer their questions better. So my proposal would be that the legal division publish a advice letter report on a monthly basis. It'd probably be towards the end of each month in order to give commissioners time if they would like to have one of those letters put on the agenda specifically for the next month's meeting. We could also distribute it to any members of the public who signed up through our listserv process, so they could receive the advice letter report every month. If there were letters that the commission wanted to discuss, they could put it on the agenda each month as its own item. I think this would provide better notice to everybody involved. So I was just going to pitch it here before I took it to the whole commission.
All right, thank you, Mr. Bainbridge. Commissioner Hayward, what do you think?
I think that's a good idea too. Partly because it spreads the workload of the part-time commissioner over a broader period of time. I mean, sometimes, the agenda gets posted, and if there's a lot of regulatory stuff on it or a particularly potentially contentious stip or something, the advice letters kind of get read, at least speaking for myself, later on in the analytical process. And this would spread out the burden of having to do that all as I'm preparing for a meeting. I think it's a great idea.
All right. Again, I would agree with Commissioner Hayward. I do think this is another idea from one of our division chiefs that's worth consideration by the full commission. I appreciate you bringing it to our attention, Mr. Bainbridge. Do we have any public comment on item 5, either by phone or digitally? Seeing and hearing none. Mr. Bainbridge, what's your timing like on presenting this in a more refined form for the full commission?
I could, at the May meeting, just kind of give the same explanation I gave here. It's up to the person making the agenda as to how they want to handle these sort of things. It wouldn't require formal action by the commission. But I think I could bring it up in the course of the advice letter report in May, and maybe you could solicit the opinion of the other commissioners at that time.
Okay, that sounds reasonable to me. I do think it's important that the full commission have an opportunity to talk to you about that and make sure that they're okay with this approach as well. So let's go ahead and add that as a discussion item for May then.
Okay. Thank you.
All right. Thank you. So moving to item 6, this is our legislative update. Mr. Bainbridge, I think you're pulling double duty today and also handling that. Is that right?
Yeah. Jay is not available today, so I'll give the update. In general, the update is we've been told by Senate and Assembly election staff not to expect much, if anything, that's PRA related to move over the next few months, just due to all the other important things going on in a very condensed legislative session. Specifically, we got word recently on a few bills, kind of formally that they wouldn't be moving forward. That would be the 2 Berman bills, the AB 2407 and AB 2505. In both instances, it had nothing to do with the bill itself. It was just they didn't anticipate there would be time for these sort of things this year. SB 423, which was the committee bank account bill. It's a 2-year bill by Senator Umberg. We were informed this week that bill had been amended to concern other matters not within the jurisdiction of the commission. So that is no longer a bill that we're going to be following. I think at the May commission meeting, we should probably take the formal step of removing our sponsorship of the bill, since it's no longer something within our jurisdiction. Similarly, AB 2889, which is the Assembly Member Mullins bill that was cleaning up the local contribution limits bill from last year. They've informed us that will not be going forward this year. They plan to address the ambiguities that were identified next year when they have more capacity to do so. Similarly, AB 3078 is the Assemblymember Garcia bill concerning behested payments. The staff over there at their office informed us they weren't moving it forward this year, but we're interested in the topic and working with us. We've had a phone call meeting with them that I think was pretty productive in fleshing out some of what they're trying to accomplish with that legislation and getting our thoughts on it. So I assume that will be a topic later for today, and then moving forward with Assemblymember Garcia's office. Other than that, I don't have an update other than a new bill, the one PRA bill. We actually have a new PRA bill that came through just a couple days ago by Assemblymember Levine. It's picking up where Assemblymember Garcia left off on the use of public funds for campaign activity. It's significantly different than the version we saw last time around from Assemblymember Garcia. I haven't done a complete analysis of it yet, but to me, it's quite an improvement from the prior version. It's attempting to be very clear as to what is permissible by a local and state agency and what is not in terms of educational material versus campaign advocacy. So over the next couple of weeks, we will take the time to look at that more closely and have an update for the commission come the May meeting. That's all I have. If there's any questions, I will try to answer them.
On AB 2467, the Levine misuse of public funds bill that you just mentioned, do we have an indication from his staff or his office that they do in fact intend to pursue that this year?
Yes, they do. They just got the language printed this week, so their intent is to try to pursue that this year.
Okay, and I know you said a moment ago you hadn't had enough time to look at it in depth, but just based on your cursory review, I know we provided, I think, some language to them on this topic. Do you know whether did they accept our language? They take it in a different direction? What's your preliminary sense?
No, it's very similar to the language we had presented to them as a potential draft. I just haven't had a chance to compare line by line how it is. It does have a few differences that I haven't figured out exactly what they are yet.
Okay, great. Commissioner Hayward, do you have questions for Mr. Bainbridge on our legislative report?
No, I don't.
Okay. I have one final question, Mr. Bainbridge, and that's trying to find which bill it is. Yeah, it's AB 2079. We had talked about this, I think, a couple meetings ago, contribution prohibition on investor-owned utilities. Two questions for you. One, do you know whether that bill, whether they intend to move that bill this year or similar to other PRA bills, it's going to kind of fall by the wayside? And secondly, I think we had asked staff to take a look at some issues surrounding regulation of investor-owned utilities. And so I don't know if we have an update on where we're at on that.
Sure. Yeah. On your first question, I don't know. I haven't heard that they're not planning on moving it. What I do know is the head of the elections committee in both the Senate and the Assembly has said they don't intend to move bills that aren't COVID-19 related or the census or something that's being impacted. So whether the author wants to, I think the author wants to move it. I assume it's still out there. We haven't heard they don't, but I don't know that the people in charge of the committees they would have to go through are planning on moving it. Assuming it goes through those committees. So far, it's assigned to Assembly elections. In terms of analysis, we've done a preliminary internal analysis of the bill. It's the very unsatisfying constitutional law answer of it depends on whether it's constitutional. It's a limit on contributions, which there's an easier standard to find those constitutional than expenditures. But what we don't have yet is an articulation from the author of what is the government purpose that they're attempting to serve with this prohibition. So until we have some information about that, it's hard to analyze whether it meets the level of scrutiny required. So there's an egghead answer of we don't know at this point, but we can give a little bit of more context to the commissioners so they can maybe try to make a guess in May.
Okay, I appreciate that. All right, thank you, Mr. Bainbridge. Commissioner Hayward, any more questions or comments for Mr. Bainbridge on the legislative report?
No, I mean, I kind of knew that was the answer on AB 2079 since I've written in this area. And so I am, I'll be interested in seeing sort of, I mean, obviously what we're worried about is viewpoint discrimination. So it'll be interesting to see what you guys think of.
Yeah, I don't know isn't usually the right answer, but I'm glad it was in this instance.
All right. Do we have any public comment either on the telephone line or digitally for the legislative update, item number 6? Hearing and seeing none. All right. We will then return to item 3 at this point. This is our behested payment discussion, hopefully with the engagement of interested persons, regulated members of the regulated community, other folks who have an interest in this issue. I certainly think that it's timely for the commission to be looking at this issue now and taking some time, I think probably over several meetings, to gather input and take a very thoughtful and deliberate approach to this particular issue. So with that, I know we have a staff memo, a very, to my mind at least, very well written and comprehensive staff memo by Senior Counsel Harrison. And so at this point, Ms. Harrison, would you like to sort of hit the high points of your memo?
Certainly. So what I'll do is provide a summary of why we're talking about it right now, and then frame the issues with a general description of the law, and then briefly outline issues that that we're aware of. And then my thinking is that I'll turn it back to you, Chair, in order to allow the interested person's comment period before we talk about any proposals or get further into the details on it.
Right.
So
the only thing I would say, I guess, at the outset is we just heard as part of the legislative report that Assembly Member Garcia has chosen not to move forward with her bill. So to the extent that that informs your thinking or discussion on that issue, I just wanted to make sure you knew that.
yes, thank you. So as background, the Commission recently requested a review and discussion of behested payment reporting issues. Behested payment transactions operate outside the Act's strict gift and contribution disclosures and limitations. The potential political influence involved may be publicly known only to the extent that behested payments are reported. This request follows recent proposed legislation that the chair just discussed to change behested payment reporting, as well as recent media accounts of transparency and compliance issues. Staff prepared the memorandum with background on the issues involving behested payment reporting, as well as outlining some proposed suggestions. And at this time, the Law and Policy Committee is seeking input from the public on the behested payment reporting requirements. To frame the issues, basically under the Act's transparency laws, an elected officer or a Public Utilities Commission member who requests payments from one entity to be given to another entity may be required to report the payments. A request may take the form of a direct request or a suggestion or an action in concert with the third in the memo. And today, instead of repeating elected officer and PUC member, we'll refer to those collectively as the elected official. So generally speaking, a payment is considered behested and subject to reporting in the following instances. First of all, the payment is not made for an election related activity. That is a contribution. Then we look to see, is the payment not made for a personal purpose? That would be a gift. If you cross those two thresholds, the payment is made principally for a legislative, governmental, or charitable purpose, and that payment is made at the behest of the elected official, then it is in the category of a reportable behested payment. Made at the behest of means that the payment is made under the control or at the direction of the elected official, or that it's made in cooperation, consultation, coordination, or in concert with the elected official, or that it's made at the request or suggestion of the elected official, or with the express prior consent of the elected official. Once you've determined if it's a behested payment, then you look to see the reporting requirements. So an elected official must report behested payments that total $5,000 or more in a calendar year from a single source. There are no limits on behested payments. There are also no reporting requirements for behested payments that are less than that $5,000 threshold in a calendar year from a single source. In terms of what must be reported, an elected official must report the behested payment in 30 days of the qualifying payment being made. At that time, they must provide a report showing the information regarding the payor and the payee, the name, address, purpose of the payment. Then once that $5,000 threshold is reached, any subsequent payment in that calendar year must also be reported within 30 days from the date the payment is made. So that's a summary of the background on the law that applies, very general. And now just to summarize the issues. Some of the issues that have arisen in the behested payment reporting arena is a need for plain language in the statutes and the regulatory language to clarify the guidelines. The term itself, behested payment, is a bit archaic. Behested payment applies, made at the behest of, applies in multiple contexts within the Act, beyond the topic that we're talking about today, those behested payments that are subject to reporting in that charitable, legislative, governmental purpose realm. These definitions are self-referencing. What is a behested payment? Well, it's a payment made at the behest of an elected official. The nature of the language results in safe harbors, which by their nature tell you what you don't need when you don't need to report. So then we look, there's reporting issues. The whole nature of a behested payment transaction is that it's a third-party transaction. So an elected official is required to report, but this is based on receiving timely data from the organization involved. An organization needs to provide the official with a list of all donors responding to a solicitation that's involved the elected official. Often officials are expressing that they wish to lend their name to a worthy cause, but they believe the reporting requirements may be burdensome as a result, especially when working with a small local charitable organization. And the rules for reporting seem to come almost as an afterthought in these situations, especially when you have, as recent events have shown us, a time of crisis. The reporting duties require tracking in addition by the elected official, because you're not just talking about a one-time solicitation and payment situation, you're looking at a single source over a calendar year. So the official must then aggregate payment data from one organization with payment data from other records to determine if that threshold has been reached for that single source. Then there's issues of attribution. What if a behest is in a solicitation, but the behest is very general? Has a behest been made? What if the solicitation is clearly a behest, but it involves multiple elected officials? And then you get to the realm that we're in now of social media solicitations for fundraising that might be widely viewed in a community through posts that are reposted. So we notice that in these circumstances, there is a limited duty involved in behested payment reporting. It's not a limitation like you have in contributions or gifts on the amount. It's a requirement to report. And the basic rule, as said in an earlier analysis of behested payments, is the rule is ask and ye shall report. So the duty on the elected official is that when they're making a request for payment or a suggestion or working with an organization, they need to let that organization know that they will need information from them in a timely manner. Another issue on timeliness that Ms. West might speak to too is the reporting goes to an agency rather than to the commission. And those reporting timelines can be the biggest issue in a behested payment reporting problem. The other big issue, two big issues, is that these behested payments may be not getting reported. Recent media accounts have revealed that payments may be flying under the reporting radar, and that is the only limitation on behested payments in this context. The other issue is that behested payments may be providing ancillary or fringe personal benefits, and this raises gift and conflict of interest provision issues. So if you would like, we can pause right now and take input from interested persons, and then we can perhaps discuss possible recommendations depending on how much time we have remaining.
Thank you, Ms. Harrison. Before we move over to the interested persons, I wonder if Commissioner Hayward had any questions for you from your memo first.
I thought the memo was really terrific. Uh, Noticed that Nick Sanders in his comment this afternoon has said that, you know, he thinks that this is probably the most thought that anyone has ever put into the state's behested payment laws. And I think that may be, in fact, part of the problem that we're dealing with is this we sort of, you know, regulatory interpretations in 1996 that apparently set everyone's hair on fire at the time, led to legislative action in 1997, so that behested payments wouldn't be treated as contributions. At least that's my understanding of the history. But they kind of are and kind of aren't. And I've been jurisdictions do, and I didn't find any really good fits. I think Florida has dealt with this a little bit, but it's kind of an area that isn't part of the traditional campaign finance playbook, if you want to call it that. That we saw that isn't moving kind of revolve around the public official sphere, that there are solicitations out there that officials responsible for that they aren't aware of, or they aren't aware of the scope of that, and the sort of, you know, fundamental unfairness of making somebody report something that they don't know is existing. And I think that's a big problem. I also, you know, retain my concern that when the money is used for something that looks kind of giftish, that might be a place where we should look to see if there's slippage that we can fix. That seems to me to come about when the payment is being used for a legislative or governmental purpose rather than a charitable purpose. I think we all kind of get what charities are, but some of that other, you know, the office furniture type stuff looks to be a bit different. So I guess, I mean, those are my preliminary thoughts. I do sympathize with the members of the regulated community who are anxious about being held responsible for reporting something that they either don't know about at all or they aren't clear what the scope is.
All right, thank you, Commissioner Hayward. Ms. Harrison, I had a question for you. Could you just sort of briefly walk us through the Weiner advice letter and the Rivas advice letter, and sort of explain to your mind what the key differences were in those advice letters for arriving at different conclusions as to whether in the first instance, or the Weiner advice letter, there was not a behested payment obligation, but under the Rivas advice letter, the commission concluded that there was an obligation to file a behested payment report.
There. First of all, it's important to understand that the Rivas letter was an informational assistance letter. It was based on sort of general scenarios, whereas the Weiner letter was based on an actual occurrence in fact. So there were specific facts that were interpreted, and that always makes a difference. So in Rivas, the idea was that it was presented that the official had consented hypothetically in a couple different solicitation. And so in that instance, you know, absent, well, let me back up. So if you're looking at the regulation at 18215.3, there's a safe harbor provision where an elected official is not featured. That means they don't appear in the solicitation. And so that safe harbor wasn't applicable in Rivas or in Weiner, because in both situations you had an elected official featured in a solicitation. In the Weiner situation, the official wasn't aware, given the circumstances of the gala event, wasn't aware that an invitation was going to go out where he was being honored. and wasn't aware that he would appear in the invitation. And so those circumstances and how the actual invitation appeared were determinative in that situation. In the real solicitations, all involving an elected official who consented to be featured in the solicitation. So in that instance, we look, in both cases, we're looking to see if subdivision A in that regulation applies. And basically that's an application of the definition of made at the behest of, which involves that long laundry list, which goes all the way from a direct request to a suggestion, to coordination, to cooperation. So in the instances that we were being presented with in the Rivas letter, there were those types of hypothetical facts presented that showed cooperation and coordination.
So just so I'm clear then, in the Weiner advice letter, the Dr. Gould was informed ahead of time that he was going to be an honoree at the event. So he knew he was going to be honored at the event. But he wasn't, at least under the advice letter, he wasn't specifically told that as an honoree, his name would appear in the solicitation. And that was a significant fact for purposes of coming to the conclusion that the commission came to in that advice letter. Is that
Yes,
right?
and I would note that it's not just a name appearing in the solicitation. The name has to be featured. It's where the name appears in a prominent manner so that it stands out, or a photo is used, or a signature is used. And so he appeared in the solicitation as the honoree, but he had no knowledge that is how this was going to roll for him to be an honoree, that he would be involved in the invitation in that manner. He, according to the facts, he wasn't aware that an invitation was going to go out.
Right. No, I understand that according to the facts presented in the advice letter. So going to your point, though, you just referenced the concept of featuring. In the situation with Dr. Gould, the advice letter states that along with the name of the second honoree, the invitation included a title graphic expressly indicating that the event was, quote, honoring Dr. Julian Gould, MD, and Randall Katz. Was that aspect of the invitation, did that qualify as featuring under the regs?
Yes, so he was featured. And so that safe harbor did not apply, and the application of made at the behest of was the determining factor. And it was determined at the time of the advice that he did not meet that standard of having cooperated, coordinated, suggested these payments. And part of that analysis is what is the involvement of the official and what is the effect that it would have on someone receiving that solicitation, that invitation.
Okay. Is the standard that we're looking at here, is it actual knowledge by the elected official, or is it, do we use sort of a reasonable knowledge? So if I'm told that I'm going to be honored at an event, am I expected to presume that I might be mentioned in the invitation?
I think what you're asking is, when would an official know that they were in coordination?
Correct.
So I think that that's highly factually dependent, and that's one of the issues in behested payment reporting determinations. So it would depend on the facts involved, and I think it would be what would be reasonable for an official to understand in the circumstances. So the Rivas letter is stating that where you've consented to have your photograph in a solicitation, that you are coordinating and cooperating with the organization and saying, yes, you can use me as part of this fundraising solicitation.
Right, and that's sort of my point, though, is if instead of explicitly consenting to it, if Assemblymember Rivas had agreed to attend the event as a guest and she didn't ask whether she was going to be featured in the solicitation, and nobody from the organization told her specifically that she would be featured, it would seem a lot closer to the Weiner advice letter, right?
That's correct, yes.
Okay. All right, I had another question for you, and this goes to some language under the heading of issues, subheading of reporting issues, data, timeliness, crisis period, and attribution. So you reference the fact, I'm sort of paraphrasing, that charitable organizations and elected officials are accustomed to tracking, aggregating, and reporting payments. And I think that's true to a certain extent. But my question is, in what other circumstances do elected officials, at least with respect to the Political Reform Act, have an obligation to obtain and aggregate information from multiple third parties for purposes of meeting their own reporting requirements? Because I think it's a little different when you're an elected official and you're receiving contributions. Of course, you have a list of your contributors. You can cross-reference your list. This circumstance, and you alluded to this earlier, really what they're doing is they have to go out and obtain information from a third party, and they are completely reliant on that third party giving them the information in order for the public official to meet their reporting obligations under the Act. So are there other circumstances outside of behest where we ask that of our public officials?
I'm not aware of it, but perhaps Mr. Bainbridge can comment on that. Or Ms. West.
Can you see me? Okay.
Yes.
Yeah, so there is that same requirement for sub-vendors. We've had the same issues where people say, well, it's not fair because we can't get the information from the sub-vendor. And so over the years, the rules have changed to put an obligation on other people to provide information to the committees. But it is the same type of information where they have to get it from a third party in order to have their reporting be complete. Did you have anything else, Dave?
Yeah, immediately came to mind is the situation of aggregation of contributions to when it's attributable to a single source. You may get checks from entities that look different, and you have a certain obligation to know if it actually is the same source. I can't think of the specific situation, but I think there's some similar requirements in the lobbying context of getting information from a third party for reporting purposes.
So, and please, any one of you are free to answer this, but so suppose that you're a public official and you want to comply with the behested payment reporting requirement, and you repeatedly ask a nonprofit who you've behested contributions to give you the information, and they don't provide it. What do you do?
I guess that's me.
Or what do you do, Ms. West, in enforcement under those circumstances?
You know, when we're discussing all of this, it's all very relevant because we are talking about these exact factors when we're talking about adding behested payments to the Streamline program. So one of the biggest complaints is that these nonprofits are not providing it. And what has happened over the years with sub-vendor, once it became a violation for committees in order for them to have to file, they needed the information. At first there was complete pushback saying, you know, we can't make them provide this information, this isn't fair. But as committees were prosecuted for it, they stopped dealing with vendors that didn't provide the information timely. And so it was kind of supply and demand, open market kind of fixed the problem, which sounds heartless and mean, but at some point you're not going to deal with charities that don't provide you the information because you got in trouble the last time you did something nice for that charity. And it's the same process that goes through with every new law when you're depending on someone else to provide you that information. I also would note that before legislation shut down, one of enforcement's proposals was putting an onus on whoever is receiving the benefit of the behest that they have an obligation under the Act to provide the information, which is the safeguard that we would be able to provide the committees to where they would have some sort of way to have us help them get the information in a timely manner. But of course, it's mitigating, and it's one of the factors that we put into the proposed streamline.
All right. Again, any one of you feel free to answer this, but do we currently, as part of our public education and outreach sort of panoply of programs, do we offer any specific trainings for public officials or charitable organizations on how to comply with the behested payment rules?
Yeah, I don't know that we have a training specifically on that. We do have materials on our website, and we get questions about it occasionally, but I don't think we've done a training.
Okay. All right. I guess my last question is this, and it actually made me think about it when I saw Mr. Sanders' advice letter, or excuse me, his comment letter earlier. And so, given the pandemic that we're currently in, if a public official, let's say a mayor of a city, wanted to put on his social media feed a request that folks that live in his city every Wednesday try to get takeout from a local restaurant to help support the local economy, does that trigger a behested payment reporting requirement? And how, and if so, how in the world would one comply with that?
Well, I don't think the restaurant would be a charitable organization.
So it's only, okay, well, that's a fair point. That's a fair point. What about, so
That's another
change the
burden.
fact pattern though. Suppose it's the YMCA or the Boys and Girls Club.
Yeah, that would be difficult in that situation to know. It's difficult to know when someone is giving in response to a general solicitation and when they're not. I think you make your best guesses. It's also, there's a $5,000 threshold that weeds a lot of that out. I think you're going to have a lot better idea when someone's making a $5,000 donation at your behest as opposed to a $100.
All right. Okay. All right. Commissioner Hayward, any additional comments or questions before we open it up to the public?
Just one comment based on something you said a minute or so ago that Galena responded to about what do people do if they don't get the information from the third party. Don't we have some contexts where we tell people, well, make your best guess? Like I think valuation of in-kind contributions might be like that.
Yes, that's exactly right. One of the things that we were suggesting when all of this started as maybe a regulation proposal was that there be some sort of estimation as there is in other parts of the regulations, because right now that is something that we consider mitigating, is if someone has filed their behest of payment, making their best guess. And best guess, I think under the regulations is ends up being within 20% or 25%. And that's considered under the other regulations, so we've been considering it under behested as mitigating.
All right, thank you, Ms. West. Anything else, Commissioner Hayward, before we open it up to interested persons?
No, not at this time.
All right, great. All right, then at this point, let's go ahead and open up the phone lines for interested persons to provide their input. Please be mindful that if you are not speaking, to keep yourself on mute, and to also identify yourself, please, at the outset of your comments.
This is Jim Sutton from the Sutton Law Firm, if you don't mind me going first.
Please, Mr. Sutton, continue.
Nice to talk to everyone virtually, and very happy that the commissioners are looking at this issue, because with all due respect to Ms. Harrison, the gap between what's in her memorandum and what goes on in the real world is incredibly marked. And citizens want their elected officials to raise money for local charities. And I think what's missing in this whole, what's assumed in this whole conversation is that if an elected official's name or photo is on an invitation, or if the elected official makes a speech at that event, what's assumed is that the donations were made because the elected official spoke or because the elected official's name was on there, and there was some interest in the donor in currying favor with that elected official. And that is just a huge leap, which I personally believe is completely incorrect and kind of borderline offensive. And what I think is missing from the whole analysis is the perspective of the donor. And I use these examples all the time because the dead silence from the staff about whether there was training, I think because I don't think anyone at the staff level or in the regulated community understands the rules well enough to train anyone. So when we get calls, like the examples I use is, I'm involved with the library group here in San Francisco. I go to their event every year. If one year they convince the mayor of San Francisco to send out a letter to get people to go to that event, and I buy a table for the Sutton Law Firm for $5,000, I may or may not be writing that check because of the mayor, probably not. And if the mayor were to file a public piece of paper claiming that I made that contribution at her behest, that would be so offensive to me as a donor. Now, I happen to support our current mayor very much, but let's say I didn't. Now there's a piece of paper out there that's linking us, even though that's not the reality. The other example that I use is that charities are always trying to get elected officials to be their speakers. But when most people go to those events, they are going because they believe in the cause. They might have given in the past. They might now want to give. Maybe a client asks our firm to buy a table, whatever the case might be. And again, to make the huge, unprecedented, unsubstantiated assumption that we are buying a table at that event just because an assembly person or a local politician is a speaker is just wrong. And it is bureaucratic overreach in the worst sense of the word. I don't want to, look, you can tell that I'm very passionate about this because for years we've been trying to give advice to clients about this law, and it's become very, very difficult as enforcement kind of clamps down on nonprofits. And I have to, though, disagree. Sub-vendor reporting is not an example of relying on a third party. Sub-vendors get paid by the campaign committees. They get paid thousands of dollars, and it is by the campaign committee. There is no question why they're getting paid. That is markedly different. Again, the reality is so different than what staff is talking about. That is markedly different than a charity that receives a bunch of donations after an event where an elected official speaks. There isn't the kind of absolute proof of the connection between the campaign and the sub-vendor as the connection between the donations and the nonprofit. And when the Director of Enforcement implied that maybe the elected officials will stop working with that charity, I really do not think it's appropriate for the FPPC to be passing a reporting law that discourages politicians from fundraising for their local charities. That just raises constitutional issues, raises separation of powers issues, and I don't think there is a hue and cry from the public that, well, this charity wouldn't give information to the city council person, therefore the charity is not deserving of the support of the politicians. So again, I think that, frankly, my final point is, I do not think that the commission should be making any rules without the input of the people who are affected by these rules, and that's the charities and the elected officials. And the problem you're going to come up against is any elected official who raises his or her hand and says, whoa, isn't this kind of broad? Wait a minute, this is going to discourage me from fundraising for a charity. If that elected official were to come to the FPPC, they would be lambasted in the press. And I think the FPPC has to take into account that issue when it decides how to move forward on behested payment reporting. And I would recommend some way of, I don't think staff has spoken to members of the Assembly or the Senate, but really it's city council people and board of supervisors, right? That's the vast majority of elected officials in these states. And that's who we want to encourage to raise money for the Boys and Girls Club and local, COVID charities and everything else. And also the nonprofits. That reaching out and doing some kind of interested persons meeting with the nonprofits, again, I think is essential to kind of getting this right, because right now, where the FPPC is on the existing regulations, the existing advice letters, again, with all due respect to Ms. Harrison, it is crazy talk to think that an elected official was being put on an invitation with absolutely no knowledge that that was happening. How would the scheduler? That's just so far afield from what goes on in the real world. That again, talking to nonprofits, talking to elected officials, and not doing anything else until you can really vet the unintended consequences of where the FPPC has gone on these behested donation issues. That is it.
Thank you. And of course, the whole point of having an interested persons meeting is to gather input from stakeholders, nonprofits, elected officials, et cetera. So thank you, Mr. Sutton. Do we have any other public comment?
Yes, my name is Anna Crane, and I'm speaking I was interested on behalf of the League of Women Voters. We've been looking at the issue of behested payments. I understand and sympathize with the difficulty in tracking some of these things, but I think we need to focus on the underlying issue that unfortunately not everybody behaves with the highest integrity at every moment of their life. I mean, that's a fact. And charitable organizations sometimes knowingly or unknowingly end up subsidizing things that are not really integral to the charitable purpose. We have instances in which an elected official may be, in fact, getting assistance in their campaign from a nonprofit organization through the intricate web of connections between one organization and another. I totally agree with the analyst who said that we need more clarification in the rules. The rules should spell things out more clearly. It's one thing to have somebody ask for charitable contributions to the food bank during the COVID crisis. I don't think anybody has a concern with that. It's something else when you're asking for contributions to a charity that has some political concerns. You could have an interest group that has a charity connected with it that in fact is trying to influence an election in ways that are not entirely above board. I think it's important that we focus on the underlying reason why these rules existed to begin with. It was because of abuses. Abuses still occur. To have a rule that is vague is never in anybody's best interest. Certainly clarification and the meanings are very much in order. Very difficult to write rules on this. I understand that there's a reluctance to try to put limitations on this kind of contribution because it'd be very difficult to write it, but disclosure, transparency is still warranted. As they say, sunshine is the best disinfectant. That's really all I have to add on that.
Thank you, Ms. Crane. Any further public comment?
Yes, hello. This is Jay Carson. I'm an attorney at Nielsen Merksmer. I tried submitting a comment through the public forum, but I'm not entirely sure it went through. So I just thought I'd chime in here really quickly. I want to say I appreciated the memo and laying out the issues with behested payments. One thing I was hoping to see in the memo, but didn't, was a reference to potential behested payment donation reporting by lobbyists, lobbyist employers, and $5,000 filers. So in the lobbying manual, on it's chapter 4, page 13, section K, is a section on behested payments. And the last paragraph there says when a lobbyist employer or $5,000 filer makes a behested payment, you must also report the payment if the primary purpose of the payment was to support lobbying activities. So I think it would be very helpful for staff and the commission to look at the potential reporting obligations of behested payments on the lobbyist employer and $5,000 filer side. As far as I'm aware, this standard is not in the regs or anywhere else. It's a statement in the manual, so that makes the reporting somewhat complicated to understand. So the request would be to have staff and the commission look at that issue, to analyze it and include, reference to what reporting obligations there may be on the donor side, in this case for lobbyist employers or $5,000 filers, and then obviously allow public comments on how the regs may shake out and everything else.
Thank you very much. Do we have any additional public comment? Going once, going twice. All right, Commissioner Hayward, did you have any additional comments or observations? You're on mute, Commissioner Hayward.
I've been doing Zoom like 3 days a week for a month, and I'm still putting myself on mute. Clearly, I've got a very not very steep learning curve here. Anyway, I just want to say a couple of things about things that the members of the public said, and then I want to make some broader comments. As to Jim Sutton's point, I hear him. I have never, and continue to be really unhappy with disclosure requirements that knit people together who may not actually be political supporters. We had that with some of the Disclose Act stuff where, if a charity was one of the organization's top donors, the charity's name would appear on a piece of political work that a charity could never pay for. And, so that all that kind of junk disclosure stuff really bothers me. And so I'm sympathetic to that. And I do hope that charities and officials who raise money for charities will participate as we move forward, because I think there are some dynamics here that we're ignorant of because we only see the FPPC enforcement and interpretive part of California politics, and there's a lot more to it. But I also think that Jim's problem may be with the 1997 legislation that put this in the statute to begin with. Because as I understand it, that was a response to some interpretive overreach in 1996, which I said earlier, apparently set everyone's hair on fire, and justifiably. But instead of sort of walking that back, the legislature in its infinite wisdom decided to craft a behested payment reporting requirement without limits and put that in the act. Quite possibly because that was more palatable than pushing back at the disclosure for political reasons, but there we are. Let's see, as to Ms. Crane's comments, I think it's true that not everyone behaves honorably all the time, but we can't really, as a government agency, start picking which charities we think are more political. So political, they fall outside the realm of charity, which might matter in the tax context. I'm not sure how much that matters here. And then Mr. Carson's comments. Yes, I think the lobbyist part of this puzzle wasn't one that I had really thought about either. So absolutely, let's put that in there. And that's a good segue to the larger point, is that it seems to me that there may be some active dispute right now as to what the regs really do require, and some concern that with the lack of training and the lack of materials, that maybe the commission hasn't come really to grips with what we think the law says now. And that seems to be something that we really need to pin down if we're going to have a good conversation about what interpretive changes and legislative changes we might want to see. So I think that would kind of be my first suggestion, is that as as Mr. Sanders suggested in his email, that maybe the exercise of putting together a FAQ and some sort of manual type training materials in this area would be a very productive one, because it would focus us on where there's agreement in interpretation and when there really is a lot of ambiguity and not agreement in interpretation. That's all.
All right, thank you, Commissioner Hayward. Mr. Bainbridge, I know you mentioned earlier that we do, in fact, have some training materials already on behested payments. Do you think that those could be, yes, to Commissioner Hayward's point, could those be beefed up a bit, or perhaps made clearer for folks?
I don't know exactly what's on our website. We have a lot of material on our website. So I'd have to look and see what's there already. We could always do more. My only hesitation would be if there's going to be significant changes in this area of the law, preparing trainings and those sort of things at this juncture doesn't make a whole lot of sense in terms of use of staff time.
Commissioner Hayward, what's your response?
If I could respond to that, I'm not suggesting we do those trainings right now.
I fear we've lost Commissioner Hayward.
I'm back.
All right, you're back. You were not suggesting that we did the trainings.
To actually train people, but I think the exercise of drafting what we think the training ought to be will, first of all, educate all 5 commissioners on sort of what the requirements are. Will give the opportunity, give the public and the public's lawyers the opportunity to tell us that we're wrong about things, and will, focus, I think, our activity on where the real interpretive problems are. But I got to tell you right now, I don't think, my fellow commissioners are feeling like they've really got their arms around, everything, anything that's any more complicated than just the bare superficial, behested payments, the $5,000 threshold, and reporting. But all the weird ways that this rule applies to particular situations, I think we're still pretty novice. We're novices in that. And anyway, so that's why I think it would be helpful to at least pin down what we think the law is right now, so that when we go off and running with new ideas, that we know they're actually new, or we know that they've been considered and rejected, or whatever.
Yeah, I appreciate that. To my mind, I think our hope was, when we announced back in April, so a month ago now, that we were going to be having this meeting today and inviting folks to offer their perspectives and experiences with behested payments rules, that would be a good way to start the process of identifying, to my mind at least, the different scenarios, and to borrow Mr. Sutton's terminology, the real world situations in which the existing rules play out, so that we identify the areas of tension, the areas of ambiguity, and approach them in a thoughtful and deliberate manner. I think we've been pretty consistent in saying that was our intention here. I will say I'm very disappointed that we only had 3 folks participate here today, because I think we hear from Mr. Sutton a high degree of passion, albeit with an unfortunate tone, but yet no concrete examples of how the rules could be improved, no concrete examples of ways in which the rules are at tension with real life. And that's precisely what we're trying to do here, and telegraphed a month ago that that's what we were doing. And I know we received a letter from some folks saying that they simply didn't have time. They'll be getting back to us with comments. And I do appreciate the current situation has made it difficult for people to engage as they may have otherwise. But I think at some point we need to start getting engagement. That's why we go through this exercise. And so I guess what I would propose is that we perhaps at the next law and policy meeting take another swing at this and again really invite people to bring to put a fine point on it, bring the real world factual scenarios in which these rules are difficult in application and compliance and lay them out there so we can start talking about them. And as Commissioner Hayward said, make it a little bit more understandable for the commission beyond what simply the rules say. How are the rules playing out? That is a challenge for folks. I think in addition to that, I think we at the commission could reach out to perhaps there are groups that represent nonprofits, both large, and I'm particularly interested in the smaller nonprofits who seem to have more of a challenge with providing this information to public officials in a timely way. So perhaps we can do some engagement with nonprofits and get their perspectives directly, and then also local governments. I know I recently had conversations with some representatives of different local governments. They were very interested in this issue. So I think there's room for us to do our own fact gathering outside this forum as well. So I think this is one where we need to continue to move forward on this and gather input. And again, I really hope that people will take us seriously and engage with us on this because it's an important issue and I don't think it's going away. So, Commissioner Hayward, do you have anything to add to that or anything that you disagree with?
No, no, you're right. I guess maybe I would specifically say to the people listening at home, as well as the people who participated today and the people who will be watching this on YouTube in the future. Memo 9/11 layout potential changes, and it would be really great to hear from people about whether or not those are useful suggestions, helpful, harmful in some way that we haven't anticipated. We've got some specific, stuff out there already that people can react to if they're looking and not sure what to say.
Right. All right. Well, thank you, Commissioner Hayward. Mr. Bainbridge, do you, or Chief of Enforcement West, do either of you have anything final that you wanted to add before we conclude our law and policy meeting?
Nope, I'm good.
Nothing for me either.
All right. Thank you both. And thank you, Ms. Harrison. Again, I thought your memo was very well written and appreciate the time and effort that you've been putting into this issue for us. Again, it's an important issue for us to continue working on. So with that, do we have a motion to adjourn?
So moved.
All right, second, Ms. Linker.
Commissioner Hayward,
Yes.
Chair Matich.
Yes.
The motion passes.
All right. Thank you, everyone.
Bye.